You're watching Capital City Sunday.
Rick Esenberg from the Wisconsin Institute for Law and Liberty joins us now. The conservative law firm submitted a set of maps for the court to consider. Rick, thanks for joining the show this morning.
Thank you for having me on.
Of course. So what do you make of the legislature passing Governor Evers' maps this past week?
Well, they did what litigants often do. They decided to make the best deal that they could. I think that they were afraid that the court was going to pick one of the maps proposed by parties aligned with the Democrats. They thought that of those maps, the maps proposed by Governor Evers were the least disadvantaged to them, and they decided that they would, go with those, and so they decided to pass them without any kind of amendment.
What was your thought on that, as far as them going and making this decision as opposed to waiting on the Supreme Court?
Well, I mean, it's really their call. I think there is something that is unfortunate in the whole thing, in that there really was a uniform perception that the court was going to rule in a particular way. And while that's not always avoidable, I think it's better for the judiciary when the public is not so convinced that they know what it's going to do, when they believe that that the court has an open mind. Now, this is not to say that the court didn't have an open mind. I can't comment on that, but I think that there was a perception that this really was a done deal, and I think that drove the Republicans in the legislature to pass a set of maps that they certainly did not think were best or fair.
I want to stay on that topic there of perceptions and the state Supreme Court. Could a future conservative Supreme Court majority strike down these maps if the governor signs them?
And what's hard, it's hard to know what would happen. This was a very extraordinary thing. We had redistricting litigation following the 2020 census. The issue was resolved. Maps were put into place. And then when the composition of the court changed, there was almost immediately a lawsuit filed in order to redo what the court had just finished doing. That is not the type of thing that we typically expect courts to do. The court did not take up the partisan gerrymandering claim that was the principal claim in that lawsuit, but it used a different idea about municipal islands and a lack of geographic contiguity to essentially announce that they were going to redo everything that happened in 2021.
So your point is well taken. The Supreme Court overturned these maps based on contiguous territories. But the consultants who did take a look at the maps and analyze them, your maps that Will submitted, they said were a partisan gerrymander. So just for the viewers' information, but given that Will and Law Ford both had maps that minimized how often municipalities are broken up, doesn't this show that you can have a map that's contiguous and reflects the electorate?
Well, it depends what you mean by reflecting the electorate. And I think
it would be then when people look at those statewide races and they are so close, then we look at the legislature, which is so overwhelmingly Republican, it does not jive. I think that would be reflecting the electorate.
But the problem is, and this is the thing that the consultants did not address, and the court did not address, is that we have to follow our Constitution. And our Constitution calls for single-member geographic districts that are contiguous, compact, equal in population, and that minimize municipal splits. Now, I used to teach election law. When you get to redistricting, one of the first things you do is show that depending upon where people in the state live, a system of single-member geographic districts like that will not necessarily match the partisan support for statewide candidates. And that is not a bug in the Constitution, that's a feature. The people that drafted our Constitution thought that localism mattered. It's not that land will vote. I mean, that's a silly argument that some people make against this. It's that the Constitution organizes people into geographic districts on the assumption that their local concerns matter and that a representative should represent a group of people who live in proximity to one another. Now, our maps perform better than Law Forward's, but certainly it's possible for the Republicans or for the Democrats in Law Forward to gerrymander a set of maps which will meet some statistical metrics, but will be intentionally drawn to maximize the political advantages of one party. Now, there's allegations that the Republicans did that in 2011. And I think that however you think of that, it's fair to say that Law Forward and the groups aligned with the Democrats did that in this litigation. In fact, they said they're doing that. They said that they set out to match this partisan support in statewide elections.
Rick, I'm
and
curious.
That really isn't what our Constitution calls for.
I'm curious, if the governor signs these maps, is Will going to file a lawsuit in federal court to strike them down?
Well, I don't have any plans to file a lawsuit in federal court to strike anything down. I know that there's been a lot of speculation to that effect. I mean, I guess I can imagine that, there might potentially be some Voting Rights Act problems with these maps. But, federal courts don't announced a couple of years ago, the Supreme Court announced in a case called Russo that it wouldn't take up claims of partisan gerrymandering, that it thought that they were, to use the technical legal term, non-justiciable. And so I don't think anybody is going to be running to federal court to bring that claim.
Rick Esenberg, president of the Wisconsin Institute for Law and Liberty, thanks you so much for taking some time to be with us this morning.
Thank you.
The governor was presented with the redistricting bill last Tuesday, which means he has until this Tuesday to decide whether to sign or veto the plan.